Good afternoon, everyone, and I'd like to welcome you to this timely and important webinar brought to you by the ABA section of Civil Rights and Social Justice and the ABA Center for Human Rights, entitled The Importance of Teaching Reconstruction and the Law Today. I'm Barrett Holmes Pittner. I'm a philosopher, journalist, educator, and the author of The Crime Without a Name, Ethnocide and the Erasure of Culture in America, and I'll be your moderator today. This session marks the third installment of our ongoing series on Reconstruction, the Reconstruction era from 1865 to 1877, a period that continues to shape civil rights, justice, and equality struggles of today. Our focus today is on understanding the legal and constitutional transformations of this era and why it is essential that we teach students and the general public about the Reconstruction era in relation to contemporary legal systems. The historical moment of Reconstruction was not just an era of legal reforms, but also a period where the nation confronted its own foundational contradictions, creating a constitutional framework that, though incomplete, set the stage for future struggles for justice and equality. As we dive into this discussion, we'll reflect on the ways of the Reconstruction era, exposed the structural tensions of the U.S. Constitution, tensions that remain relevant today. We'll explore how our cultural relationship with this document continues to evolve and why teaching its history, particularly the Reconstruction period, is vital for addressing current legal and social challenges. This is an especially important conversation as we face the continued legacies of constitutional design and consider how the shifting dynamics of race, citizenship, and power must be integrated into modern legal frameworks. To help us navigate these complexities, we are honored to have three distinguished speakers with us today. We have Sheryll Cashin, the Carmack Waterhouse Professor of Law, Civil Rights, and Social Justice at Georgetown Law. We have Etienne Toussaint, Associate Professor of Law at the University of South Carolina, Joseph F. Rice School of Law. And we have Lucien Ferguson, the Drennan Visiting Assistant Professor at Boston College Law School. Our goal today is not simply to critique the Constitution, but to envision how a deeper understanding of Reconstruction and its legacies can serve as a foundation for transformation. We'll begin by engaging our speakers with some key questions and then open the floor to audience participation. So, 1 second. I have to slide my tablet over to get to the next question. Okay, perfect. We encourage you to submit questions via the Q&A function. Please refrain from using the chat for questions. And if you don't see the Q&A controls, please ensure your screen hasn't gone idle. A recording of today's program will be shared with all registrants, so feel free to share it within your networks. For updates on future programming from the Civil Rights and Social Justice section, please visit americanbar.org/CRSJ. So let's begin our conversation on how we can continue to learn from and teach the legal lessons of Reconstruction to address the legal and social challenges we face today. So I'm going to start with Professor Cashin. You've written extensively on race and inequality in America. Could you help frame why the Reconstruction period, though relatively brief, is such a critical inflection point in American legal history? What key legal and constitutional transformations occurred during this period that law students and lawyers today should understand?
Thank you for the question, Barrett. You can call me Sheryll throughout this program. And I want to begin by thanking you all for inviting me to discuss one of my favorite periods in U.S. history, a history that I wasn't taught in public school, but I heard about from my agitating father all the time. Why? Because his grandfather, my great-grandfather, Herschel V. Cashin, served in the Alabama legislature, where I was born and raised, as a Reconstruction legislator, and was active in Alabama government, one of the early Black admittance to the Alabama bar. So in our family lore, I would hear about the greatness of Grandpa Cashin and what the Reconstruction legislature did in that point. So thank you. Now let me answer your questions. Just a quick overview. And I'm assuming no knowledge at all on the part of people, registrants. Thank you for taking the time to come to this today. So Reconstruction was the first effort in American society to make our founding self-evident truths true for Black people. Especially, the goal was to wrap citizenship around 4 million formerly bonded people. And the other thing about it that's wild is that it was the first robust period of multiracial democracy in human history, an attempt to create what W.B. Du Bois called abolition democracy. You needed a functioning biracial democracy in the South to make these new rights for newly freed Black people real. So, three critical things happened during Reconstruction that make it worthy of studying and teaching. One, the radical Republicans in Congress pushed Republican moderates to introduce three Reconstruction amendments to our Constitution that would guarantee freedom, equality, and voting rights, i.e., universal male suffrage. And this was the first time the word equal was introduced into the US Constitution. The Equal Protection Clause of the 14th Amendment also included birthright, citizenship, and extended the promise of equality to all persons. So, amending the Constitution. The second big deal about this was that Congress included enforcement clauses for all three amendments. They were intentionally interfering on state prerogatives, upsetting the balance of federal relations, federalism. Congress, prior to the Civil War, had accommodated slavery since the founding, deferring to the states, to slave states. Now they were saying no. Get with the Equal Citizenship Plan. You must ratify these amendments to rejoin the Union, and we're going to use these enforcement powers to pass new civil rights laws that will reorder your society. And the third big deal about Reconstruction is that it fostered, with these new voting rights, universal male suffrage, these biracial coalitions in the states of the former Confederacy. Blacks were not a majority. So the Reconstruction legislatures there were necessarily a coalition of Black males, Northern carpetbaggers, white carpetbaggers, and the 2% of the white population that had remained loyal to the South. And so 600 Black men of color, including my grandfather, served in these Reconstruction legislatures. And according to W.B. Du Bois, their singular contribution was to create public education for the first time, have progressive taxes, and new state constitutions with rights for all people. That was the beginning. Now, I'll stop talking now. The Supreme Court itself was very hostile to this project, but that's the lay of the land generally with Reconstruction.
Sheryl, I just have to say that was just like a perfect introduction for Reconstruction for this talk. It made me think about why I became so passionate about learning about this too, because I wasn't taught much about Reconstruction in my school. And frankly, I got really interested in it as an adult when I had to make like had to decide my career trajectory. And I was kind of uncertain what I could do. And my uncle told me it's hard to know where you can go if you don't know where you're from. And he had done like an extensive research on my family history. And then I started learning all these stories about my ancestors, including our lives during Reconstruction, which had way more documentation than our lives prior to Reconstruction. And it's like that just created like a spirit in myself to want to go out and do more things. And so like that erasure of it is really profound. And so hearing someone who like has had that cultural narrative like steeped in themselves from like a child was really, really great to hear. And another thing I thought was really wonderful about what you said is whenever I talk to somebody about Reconstruction, they always think of it as almost like some exclusively African American or Black thing. And then I have to remind them that like like white people passed those amendments. Like they were in Congress. Like it was a biracial thing. There's actually a lot of like moments, examples of Reconstruction that should inspire white Americans and people looking for diversity. And I constantly have to like remind people of this because they think of it as just like something for like one race of people and not like something that's championing diversity and equality in the US. And so I just thought that was wonderful. I really appreciated it. And now I'm going to kick it to Etienne as we just keep on moving. And so, or Professor Toussaint, um, many law students graduate with limited exposure to the legal developments of the Reconstruction era. How has this gap in legal education shaped our broader understanding of the Constitution or constitutional law? And what methods have you found effective in integrating Reconstruction into the law school curriculum?
Yeah, well, thank you so much, Barrett, for the invitation, for the question. Feel free to call me Etienne throughout the conversation to make it, a conversation among friends, which I'm happy that it is. So I really appreciate this question. I think it's so important. Like so many others, I had a very limited educational exposure to the Reconstruction era, certainly in elementary and high school at the very cursory level. And even in law school, it wasn't an era that we delved very deeply into in the way that I tried to do in the course that I teach and in some of my scholarship that I'm continuing to explore. And you asked, what does this limited exposure do, not just in the context of legal education, but perhaps more generally in our broader national conversation about constitutional law, constitutional change, and the issues of social, racial, and economic justice that continue to confront our political conversations. And I think the impact of that limited exposure is significant. I think number one, it distorts our understanding and perception of constitutional change. How does the Constitution change? How does it evolve? It very much reinforces a static view of the Constitution as a document that is not inherently intention, but a document that merely needs to be interpreted in the correct way by individuals who have the requisite knowledge and expertise, right? And therefore, our constitutional debates become conversations about the smartest person in the room who can offer the best analytical tools to interpret the true, divine meaning of the text. I think the Reconstruction era really provides a beautiful legal history about the way that our understanding of the underlying principles in the Constitution have always been fraught, have always been debated. And, one could think about the very concept of citizen, which was very much in tension among the various states, even leading up to the Reconstruction era. We're taught a very simplistic division between North and South, between free and unfree, citizen and non-citizen. But it's much more complex than that once you delve into the details and understand that even in so-called free states in the North, the question of who was a citizen and what that brought with it was very much contested, not just along racial lines, but also along gender and class lines as well. And those conversations, those various political views, kind of came to the forefront during the Reconstruction moment. And so providing students and citizens more generally with a deeper understanding of those debates, I think help us to see why many of those tensions bore out in a variety of different ways in the years following Reconstruction. Certainly the root of some of our tensions between the federal and state governments, the root of federalism. You can see some of those tensions in a really profound way as you study the Reconstruction moment. And also some of our questions around civil rights, what they mean, and what the extent of those rights are. Again, were hotly contested. I think secondly, something that's very important to our current debates today is the role of federal power in enforcing equality. One of the significant initiatives during the Reconstruction moment was the creation of the Freedmen's Bureau, what is commonly called and known as the Freedmen's Bureau. And then I think that gets into a question of what role should the federal government play in advancing racial and economic justice? Should the government play a more limited, conservative, restrained role, or must the government play a more active, a more interventionist role? And part of answering that question is reckoning with the persistence of the backlash to racial justice efforts. And the Reconstruction moment really helps us to understand that there has always been a concerted effort to embed white supremacy, social hierarchies into legal doctrine and into legislation. And the Reconstruction moment really helps, I think, us to understand why racial and economic subordination across our country's history is not something that can be understood solely as individual actions by bad actors, but something that has always been structural, something that has been embedded into law and often reinforced by the court system itself. And the Reconstruction moment helps us to understand that in a profound way, helps to explain why constitutional cases like the slaughterhouse cases or Plessy v. Ferguson were so significant in how they were speaking to the Reconstruction moment. It helps us to begin to grapple with theories like the cycle that Barrett has put forward, and other scholars discuss this notion of a second Reconstruction, a third Reconstruction, this idea that we're returning back to these same debates. And I think that provides more context to really discuss what's happening today and how we resolve these challenges that we are being confronted with.
No, I think that's so true, and it's really significant based off like what Etienne was talking about, what Sheryl's talking about is that like Reconstruction was an era of action. It wasn't theoretical. Like we're trying to reconstruct the US in various ways to include equality and equal as part of it. And that is we're going to try this, and then there's going to be some pushback. So now we have to make an enforcement mechanism to make sure that we can keep on creating structures that promote equality. And with each time that happens, there's a different type of pushback that then has to be addressed. But if you have a clarity that you're trying to create equality, this is the process, this is the vision, and that's structuring the law, that's understanding the spirit of the law. There's so much about it. And yeah. So I'm going to kick it to Lucien Ferguson. Before I ask him this question, I just want to say I met Lucien about, I think, like sometime in November. I gave a talk at Harvard about my American cycle theory that Etienne mentioned, and he came up and he said that he really enjoyed it, and I was like, "Oh, great, that's wonderful." And then I looked at his scholarship and I said, this is one of those white allies from the 1860s, but it's like it's happening today. This is wonderful. I'm gonna reach out to him and bring him into the conversation. And once he got the invitation for this, he's been so exuberant to participate. And it's like this is the energy that we need, because most people think of this as just some topic that only African Americans are supposed to care about because it only pertains to them. But like this is something that pertains to all Americans, and we need that energy from everyone, not just African Americans and not just the people that were part of America back then. This is something that relates to Asian Americans and all sorts of and Latinos and all sorts of immigrants. It's the same conversation about equality and reconstructing America so that we engage and promote that. And so, anyways, it's just very happy. It's just a lot of fun to see Lucian Luke again, and we met once and it was pretty clear. So, anyways, here's the question. So, and this is going to Professor Ferguson or Luke. How might a more nuanced understanding of Reconstruction era legal developments challenge or enrich prevailing theories of constitutional interpretation? So, does the Reconstruction era offer alternative frameworks that could reshape how we approach the Constitution or constitutional law today?
Yeah, absolutely. And I just want to say I think this project is crucially important, especially right now. I couldn't have been happier, Barrett, that you brought me along, and I'm really honored just to be part of this panel with people that I really think of as, among the leading intellectuals of this moment. Sheryll, your work was crucially important for me when I was doing my dissertation. And Etienne is like a brilliant, just rising star whose work is super important for me right now. Barrett, your book is unbelievable. So I'm just so happy to be here. Um, to your question, I think the Reconstruction moment speaks to questions of constitutional theory, interpretation, framework in several important ways. And one thing I want to say, just sort of prefatory, is I think when we think of turning to history to make constitutional interpretations or theories, the word originalism comes to mind, and there's the idea that the Constitution is fixed at the time of adoption. There's a history behind why that might be the case, and it has to do with conservatives for decades pouring money into promoting this particular theory of the Constitution. And so, one thing I want to say, sort of right off the bat, is that you don't need to make a legitimate constitutional argument or theory. You do not need to do a deep dive into academic legal history. Look no further than Brown v. Board of Education, which justified equal opportunities for education in light of its contemporary importance for modern citizenship in the United States. Second point around history and Reconstruction history, there's not one sort of historical mode of interpreting the Constitution. There are a plurality of modes of making constitutional arguments. Many first-year law students will read, a text by Philip Bobbitt talking about the modalities of constitutional interpretation. And if you, look at Bobbitt's texts, and there's some recent work by Professor Jack Balkin, you could see at least like 11 different ways of making legitimate constitutional arguments. There's the text, the purpose, the structure, consequences, precedent, convention, custom, natural law and right, national ethos, tradition, honored authority. All of these different ways of making constitutional argument can involve history and can involve Reconstruction history. So that's the first point I want to make. It's not a historical mode of reading the Constitution. We can use history to read the Constitution according to all of these pluralities of different ways of making legal argumentation. Now, what does Reconstruction history give us in terms of frameworks that is, I think, unique? Sheryll and Etienne have been emphasizing, I think, some of the most important pieces of this. And to phrase it, how I would phrase it is, one way to look at the period is it clarifies some of the foundational constitutional principles. And constitutional principles that you could either say were newly added, or if they exist in the Constitution before, were expanded to apply to everyone, regardless of race, regardless of class, at least. First principle, which Sheryll really emphasized, was multiracial democracy. And so I want to say, briefly, one way to think about that in relation to the Reconstruction amendments. All of the Reconstruction amendments enforce the idea that those ruling the US, the people occupying public offices, must be a multiracial cohort. The 13th Amendment said there are no slaves, everyone is born free, therefore everyone has a right and an entitlement to exercise political power, to hold office. The 14th Amendment emphasized this by stating that all those born in the United States are citizens and thus entitled to the rights of citizens. That was Section 1 of the 14th Amendment, which is the most enforced section and the one that people are probably most familiar with. But Section 2 of the 14th Amendment was crucial for establishing the guidelines of multiracial democracy. Section 2 said that if states do not allow adult male citizens to participate politically, their apportionment in Congress will be reduced accordingly. That was also to protect Black voting rights in the states. And then, of course, there's Section 3, which the purpose of which was to make sure that insurrectionists and those who were disloyal to the project of Reconstruction were not among the ruling class and could not hold public office or vote. And then, of course, the 15th Amendment said that political power cannot be denied on the basis of race, right? And all of these amendments, as Sheryll emphasized, have enforcement provisions, making sure that Congress can do what it needs to protect multiracial democracy. That piece is also really crucial. The principle of Reconstruction, a key principle, is that Congress is supposed to be the supreme, you might say, constitutional department in our constitutional system. That's a huge contrast to today, and one that's really worth emphasizing. So besides multiracial democracy, the other principle I really wanted to emphasize is free labor. A driving impetus of Reconstruction was to replace a capitalist economy based on slave labor with a free labor economy, where the idea was that everyone, regardless of birth, was entitled to equal life chances for socioeconomic advancement. That was enshrined in the 13th Amendment, abolishing slavery, and enshrined in the 14th Amendment, which protected a whole host of socioeconomic rights and anti-discrimination protections. And so the idea of a fair economy where everyone gets a decent chance at a decent life is also one of the core principles that comes out of the Reconstruction era. And so when we're thinking about bringing this era back, when we're thinking about reframing the Constitution, reinterpreting the Constitution, learning how to read it again today, I think these two principles, multiracial democracy, free labor, are absolutely fundamental.
Just wonderful, because I will say when I talk to plenty of Americans who care about, free labor and having a job that you provides a living, minimum wage, topics like that, but also they care about equality and justice. The absence of Reconstruction in their mind regarding like the eras or the figures or the ideas is always alarming. We're always they're going to be talking about like the labor movement in the early 20th century, or talking about the 1960s, and all of that's important, but that wouldn't have been possible without these bold, radical ideas of Reconstruction in the 1860s and 1870s. And if you look at, just stuff like Roe v. Wade and Loving v. Virginia, like the amount of things that couldn't happen without the Equal Protection Clause on the 14th Amendment is immense. And so it's really, I'm thoroughly enjoying how like just the emphasis of this talk thus far is about how Reconstruction was about diversity and equality, and that it's influenced all sorts of areas of American life that is not like explicitly like racially driven in any way. It's just about trying to make sure that people can live as equal and freely as possible, which is like the bedrock of a sustainable, stable democracy. And so it's just a wonderful point. And this is going great. So the next question is actually open to everybody. So, and it's about the 13th, 14th, and 15th Amendments. And so the Reconstruction Amendments fundamentally altered the constitutional landscape. How do you approach teaching these amendments in ways that both capture their transformative potential and the limitations that later interpretations imposed? What lessons might this offer for constitutional change today? And this is open to anyone. So, raise your hand and just go. All right, Sheryll.
Okay, so I teach two classes where this material comes up. I teach race and American law, in which it's a survey course in which we read every single major race case decided by the Supreme Court, affecting all manner of racial groups. But of course, we cover Reconstruction, and the thing I try, and then the other class I teach, a new class that is really exciting. I teach a writing seminar called Abolitionism and the Law, and I'm teaching it for the second time right now. And I teach the same cases, basically showing we have the words of the Reconstruction Amendments, and then we have the Supreme Court in their open hostility, trying to read these words as narrowly as possible. So, and I emphasize that the court had a choice, but here you have a court where most of the people on the court were former enslavers. And so for the civil rights cases in which the Supreme Court killed the transformative potential of the 13th Amendment, imposing a very narrow reading of badges and incidents of slavery, not to include freedom from discrimination. So they disempower the Republicans who wrote the amendment. Some of them are still around, from using their enforcement powers to pass the Civil Rights Act of 1875, which did what the Civil Rights Act of 1964 did, try to eliminate discrimination in public accommodations. So they limit the badges and instances of slavery, and then they also demand that the 14th Amendment only apply to state actors. And Luke, you talked about originalism, but I always point out the Supreme Court and a lot of the conservative justices love originalism, but they almost never, ever engage in originalism when it comes to the Reconstruction Amendments. They never engage with what, particularly the radicals who were pushing that agenda, what their vision was, right? And then the slaughterhouse cases in which the court renders the privileges and immunities clause of the 14th Amendment a nullity on the very first try, right? So I try not to tell students what to think, but what I do is ask them, questions like, well, were the justices participating in the popular understandings of the time, or were they resisting it? What's your view? And some of the words, particularly in the civil rights cases, it's just execrable. Where he says, I'm sure you remember this, Luke, at Etienne, where he says there's sometimes, this is like 1883 or something like this. There comes a time when a person needs to just pull themselves up by their own bootstraps and not be the special favorite. So from the beginning, they cast civil rights law giving equality and access to public accommodations as anti-white discrimination. Where have you heard that before? And I'll stop there. But and then Plessy versus Ferguson, obviously I teach that. Formalism, the court uses formalism famously to create the fantasy that Black people were equal in the eyes of law because they had their own Black car to sit on. And after that, Jim Crow takes off. It's an invitation to instantiate all manner of segregation.
Luke, Etienne, go ahead. Yep.
Yeah, I'm happy to jump in and add a little bit there. I teach a class actually inspired by Luke, called the Reconstruction Constitution. And it draws upon some text that Professor Kurt Lash has recently published in recent years, but also adds in some other primary documents, both legislative records, abolitionist writings, and other political discourse, sort of recognizing that the Reconstruction moment is not just a moment where we have new laws being created, but also a moment of very intense political debate and also a moment of cultural transformation. And so really understanding the conversations that are taking place outside of the sort of so-called hallowed halls of Congress and lawmakers, conversations that are happening in churches, among activists like Frederick Douglass and others, and by writers, intellectuals that are thinking through these issues. So I try to bring in all of those resources into the classroom conversation. Importantly, and this connects to helping students identify the lessons that Reconstruction offers for our moment today, I try to map out for students in this, and this is a paper seminar, so they are required to write a law school length research paper on a variety of different topics. I try to map out different issues that this Reconstruction moment connects to. I think traditionally, when we think about the Reconstruction era, most of our minds go to racism, equal protection, and issues that historically have been primarily faced by Americans of color, Black, and otherwise. But I think the Reconstruction moment actually gives us a lot of useful context to think about one of the most significant threats that I believe is facing our government today, which is the rise of oligarchic power or the rise of oligarchy. And there's tremendous insight that can be gained around debates related to the distribution of land or redistribution of land, debates around labor rights, and the threats of multiracial democracy. Certainly, many are familiar with the push that radical Republicans brought forth during the Reconstruction era for formerly enslaved Africans to be granted land. That's sort of connected to the famous 40 acres and a mule narrative, and a recognition that without material resources, those who are formerly enslaved would not be able to achieve the benefits of citizenship, which is having some measure of economic power that would allow them the political agency to then participate in democracy as empowered citizens. And of course, resistance from Southern elites sort of helps us understand how racism is part of the backlash that prevents that economic justice for formerly enslaved Africans. And we see the rise of convict leasing, sharecropping, and racial terrorism, right, to make that economic justice more challenging. But also a deep dive into the history, I think, forces students and others to reckon with the emergence of the Free Soil Party, which is a precursor to Reconstruction era debates. And I think really pushes us to think about the tensions between poor white farmers, poor white Southerners, and the increasing economic and political power of a small, wealthy elite in the South, right? And the slogan of the Free Soil Party, free soil, free labor, free men, right? This idea that all Americans should have economic opportunity, even those who aren't, large scale enslavers, large landholders. And Heather Cox Richardson has a great book that I also teach a class on critical legal history, where we read legal history books that try to provide a critical lens into what's happened. And one of the books that we've read this year is How the South Won the Civil War. And one of the things she notes, talking about the Free Soil Party, is how the expansion of the West was really the valve that released some of the tension between poor white Southerners and the rising oligarchic class of the Southern elite planters. The opportunity for poor white Southerners, fueled by the Homestead Act, to move out west, engage in brutal acts of violence and genocide against indigenous people, and take the land, right, sort of alleviated, at least for the moment, those tensions around economic justice that even white Americans were experiencing at that time. But to be sure, I think today we see some of those tensions returning, and we see across US history moments where those same tensions were played out. You could look at the New Deal era and the rise of the labor movement and how once again we revisited those economic justice tensions that have its roots during the antebellum and Reconstruction era. And we see once again today with the rise of a billionaire class that now get front row seats at the State of the Union, right? And the questions that that raises for what kind of democracy we have, I think those same questions were at the forefront of the debate during the Reconstruction era. And of course, Abraham Lincoln, right, coming out of that free soil movement, it was very partial to those debates and to those arguments.
Perfect. Luke, would you like to add anything?
Yeah, just really quick. Yeah, so Etienne and I first became friends talking about teaching Reconstruction, so it's so cool to be on this panel together. And the Reconstruction class I teach is called Reimagining the Reconstruction Constitution. And that class came out of my doctoral dissertation, which was very much inspired by Sheryll's work. It was on traditions of anti-caste constitutionalism in 19th century American legal history. So that said, the class is kind of divided into three parts. Students read, similar to what Etienne was saying, sort of debates on constitutional principles that happen outside of Congress during the antebellum era. They look at the women's rights movement, they look at the abolitionist movement, the colored conventions of the era, series of speeches made. And then the question is, how did those debates inform the adoption, framing, ratification of the Reconstruction amendments? And so I have the students think through to what extent were the earlier visions embodied in the Reconstruction amendments? So they both think through to what, the sort of shortcomings of these amendments, potential promises, and then they the third part of the course is looking at contemporary doctrine around these amendments and legal theory around these amendments, and asking them to sort of think about how the history might speak to and improve specific areas of practical law. And I think some of the lessons that that I think I try to sort of draw out, one of the really important lessons is Reconstruction, the shape of the Reconstruction amendments is all about determining who is in offices of power. And the course of the amendments, the course of their framing, the course of their enforcement is all kind of undergirded by this question. And so I try to get students to really think about principles of constitutional design, procedure around that. I also try to get them to think about constitutional hardball. When in December 4th, 1864, when the Reconstruction Congress convened for the first session of the 39th Congress, they did not read the names of the representatives from ex-Confederate states. They did not allow them to participate in their legislative activities. And so I think that this has a lot of sort of practical, realist lessons for thinking about our current moment and what it might take to reframe the Constitution to establish a progressive Constitution moving forward. So yeah, so it's I'll kind of just end there with those two things to draw out.
Again, I absolutely love all of this because the reason, there's many reasons why Reconstruction is so important, but I do fully believe that it helps us understand our present environment like very, very well. And the amount of questions you hear where people are struggling about like, what do we do? How do we respond to this? And then you can look in Reconstruction, you can see how bold people were back then. And now, like that radical idea now doesn't seem as radical because they did it 100 some odd years ago. Like, can we not be as bold as people 100 some odd years ago? That changes the whole framework for what you can imagine, what you can do in the world, and how you can understand the Constitution, how you can even make it even better by emphasizing equality as like within these amendments. One thing I think, and you all touched upon this, but like the fact that there was like an enforcement component to what they were doing, where it's like we have to make this not theoretical. We're implementing this. And at the same time, there's an awareness, and like Etienne pointed out with the book, like how the South won, that they knew that the battle wasn't over at the end of the Civil War, that they recognized that a lot of these former Confederates were coming back to Congress and just trying to wage that battle through like the legislative branches. Like that was the means, and we can see how that is manifesting. It manifested afterwards, especially with the Supreme Court was opposing much of Reconstruction. So there's a whole narrative of this battle that was on the battlefield morphing into all these different types of battles within Congress and the courts and whatnot. And if we aren't aware of this era, then we kind of aren't aware of the battle that's been raging for hundreds of years. And now you become completely ill-equipped for the present. You're surprised by the predictable. And Reconstruction, I think, completely changes this dynamic. It really makes us more aware of the history and the dynamics of our country and our capacity to make it a more equitable society. And so all of you guys touched upon this, and it's just great. And it's always great to hear when you guys are talking about your work that you reference the other person's work and they didn't know that was the reference. And you see the surprise, like, oh, look at that. That's always fun. That's just like we set up a cool panel here, you know?
Mhm.
This next one, I'm going to kick it to Etienne, and because now we're going to talk about social change, which is something that's quite important today. So, your work explores the connections between law and community economic development. How does teaching Reconstruction help students understand the relationship between legal frameworks and social transformation? Um, what key skills or perspectives do students develop when they engage in this history? And real quick, I just want to emphasize, I think this is very, very important because sometimes the law and just being a person who wants to have a benefit in society, but you're not a lawyer, you don't have those skills, can seem like they're just completely like two different areas. There's a big gap. But I think Reconstruction is this fascinating era where the gap wasn't as big as we imagine it to be now. Like you could be a person who was formerly enslaved or a free person, and now you have this access in a relatively small period of time. You become a representative and become a lawyer, and now all of it comes together. And I think this is just really important to put those together so we can understand how we can make positive change. So go ahead, Etienne.
Such an important question, and I think it gets to the heart of an issue that I try to tease out in a lot of my scholarship, and I think a debate that has troubled the legal academy and law schools for a long time, and that is this notion that there is a separation between law and society. In fact, we have organizations that sort of describe a distinction between law and society, and therefore we perceive a world where law operates in isolation, interpreted by judges, performed by lawyers in a variety of different ways, and then social movements respond, somewhere in another room, giving their feedback, sharing their experiences, and these two things don't operate in concert. And so therefore, we embrace and venerate a legal education that it oftentimes, at least in the core curriculum, just teaches students the case law, the cases, what the opinions of the judges were, and what the text of the statute reads. And while that is critically important, I wanted to celebrate and elevate the work that Luke is doing by bringing in the voices of abolitionists, activists, community organizers, preachers, right, formerly enslaved, into the classroom, because it is important to recognize that that too is part of our constitutional discourse. And that's not a new idea, right? There's a historian, Jack P. Green, and he has a book called The Constitutional Origins of the American Revolution. And his argument in that book, in short, is that the American Revolution was fundamentally a constitutional crisis, not really a response to economic grievances or political oppression or concerns about taxation, but it was really a question of whether Britain had the right to govern a people without the people voicing consent in a democratic process, right? Is this a true republic, right? Or Republican democracy where the people themselves, the people who choose to constitute themselves in a democratic form of government cannot speak? And so it raises the question of what is in fact a constitution. That's the crisis. Is a constitution the text? And in that context, the text that's provided by Parliament and enforced by Parliament's uh, enforcement that was, positioned around the colonies, or is the Constitution the people, right? We, the people that speak and voice their opinion. And he argues in that book that that was in fact the crisis, the distinction between what in fact the Constitution is and what makes the Declaration of Independence therefore so revolutionary was Americans declaring, no, we, the people, right? We are the Constitution, we, the people, our decision to speak as one voice and to declare the principles and the values that define how we choose to live our lives. And the Reconstruction moment sort of revisits that constitutional crisis because it says, wait a minute, there's a whole group of people who live in this country who aren't being included in we the people, right? And so you have Frederick Douglass and others who are debating who's included in the Constitution. What do we mean when we say the Constitution? Who has a right to critique the Constitution, to be included in that? And so I say all that to say, we return today where scholars and political figures and leaders are saying we are in a moment of constitutional crisis. And I think fundamentally, it's the same type of debate. Who has a right to critique the Constitution? Who has a right to voice an opinion around constitutional meaning? And who has a right to leverage the tools of the Constitution to advance a certain vision of society? And so that very much is connected to social transformation, social movements. The Reconstruction moment provides us with wonderful examples of how community development was not only a byproduct of law, but it was a byproduct of social movements interpreting the meaning of law and then acting in their community in ways that were a response of being empowered by law. So the creation of schools, the creation of mutual aid societies, the creation of businesses. We mentioned earlier the Freedmen's Bureau. All of these efforts to rebuild communities were byproducts of interpreting a constitution that meant equality and liberty required the active intervention of government, the active intervention of community groups to provide equality. And of course, also we see the pushback from others. And so then I'll just end by noting, therefore, grassroots activism, movement lawyering, institutional building as all key aspects of realizing the vision of constitutional equality and liberty. We see the greatest examples of that in the Reconstruction moment, and right, and so that offers a model for current advocates of what movement lawyering can and should be, and also how citizens can engage in this kind of movement work by embracing their role in interpreting the Constitution and enacting the Constitution in their everyday lives.
So again, just more continuation of just how wonderful this has been so far. My next question, I'm going to open up to the panel, but I just want to emphasize just like how important I think this point Etienne's making is, where it hits me at a personal level because I'm not a lawyer. And I've been collaborating with the ABA, thanks largely to Michael Page, for years now as a journalist philosopher, where they feel that my ideas are something that can be influential and helpful And I can learn from lawyers, and lawyers can learn from me. And this is like part of the process. And I think in many ways that speaks to the dynamics of Reconstruction, for people who didn't have law degrees, people who weren't even considered like actual citizens or human beings, were able to then start voicing and expressing their perspectives and reshape the country in a much better way. And I think this, when we look at Reconstruction for what it is and not the stigmatized perspective that we've been taught or that has been erased or we've been neglected, you see how that applies to today, where so many marginalized voices, so many people without advanced law degrees, like their perspective, their voices can shape society for the better, because that's what happened back then. And we wouldn't even be able to have this type of conversation without Reconstruction. And so it's just really, really important. And so it's just, I don't know, it's significant for me because I'm not a lawyer, and lawyers bring me into the fold to talk about the law. And it's like that's like Reconstruction, you know. So this next question, it's about, reimagining constitutional possibilities, and it's open to all the panelists. So building on this wonderful discussion we're having, what possibilities do you see for the American constitutionalism if we were to more fully embrace the transformative vision embedded in Reconstruction? How might this influence how we approach ongoing challenges of inequality and injustice, and essentially like the constitutional crisis that we're confronting right now? So just open the floor to anyone, just jump on in. Sheryl.
Okay, so before I answer that specifically, I want to respond to Etienne's comment. I, I was very moved by his synthesis of all this, but I wanted to say my own take on the major choices or the major transformations between antebellum America and Reconstruction America. Yes, it was going from an oligarchy to use Luke's framing, also an oligarchy based on owning bodies. But I want to underscore the people who owned slaves in large numbers, they were like only 0.008% of the population, or 0.001, whatever. They're tiny, tiny. But these governments, they controlled them, right? And so the new Reconstruction governments, which were biracial, they not only created new public institutions like public hospitals, public education, they also installed progressive taxation to pay for these things, and demanded something of elites in regulatory ways. All of this was anathema to the oligarchs, the former planters, right? And I think we have the same basic struggle right now, right? Are we going to accept multiracial democracy where everybody has voice and can participate in politics, that frankly uses government as a source for good, that demands something of elites? Or are we going to basically have an oligarchy where elites basically get what they want out of government and government is small? When Reconstruction fell, the first thing elites did when they handed the poor man white supremacy. They destroyed and ended all this progressive taxation. So we're in that same battle now. Now, your question was about the promise of a Reconstruction constitutionalism. The new phrase is abolitionist constitutionalism. I'm going to be honest, with the current court, until we get a personnel change in the court, I think it's good that people are writing. There's a, new scholarship. You can Google abolitionist constitutionalism, Dorothy Roberts, what's his name? Hasbrook. I don't know if I'm pronouncing his name, but Brandon Hasbrook. Particularly an article entitled "The Anti-Racist Constitution, 2022, Boston University Law Review." This is interesting, fresh work it's not hard to theorize where the Constitution should go, right? But it's going to require a personnel change that it may take decades to get that personnel change. And in the meantime, the place that gives me the most hope is small d multiracial democracy that's going on in progressive spaces, but we have to continue to fight and to save multiracial democracy and have it functioning in order to get to a better constitutionalism.
Luke.
Yeah, I would absolutely second everything Sheryll just said, and I guess add, with the right people in charge, the Reconstruction Constitution gives us all the constitutional justification we need to do things like positive rights, basic worker protections, anti-discrimination protections, public education rights. It's there in many, many different ways. And it's especially there if you look to the broader context and the range of voices of non-elected officials, non-lawyers, non-judges that were also participating in the conversation. So, in terms of justification, it's there practically. It's not going to be there at the Supreme Court level. But then there are other levels where we can think about sort of nearer term next steps. So one level is states and localities. And so, for example, there's recent litigation. There's a 2018 case out of the 11th Circuit, which applied the 14th Amendment as a protection of a minimum wage law that was preempted that was passed by a Black majority local legislature, preempted by a white majority state legislature. And the 11th Circuit accepted arguments that under the 14th Amendment, this was intentional racial discrimination. And it really resonated with the ideals of Reconstruction as a 14th Amendment case. So there's like some examples like that. There's examples out of the Sixth Circuit where the court took seriously that there could be a right to education that's contained in Section 1 of the 14th Amendment. And they relied on good case law like Plyler v. Doe, which is really under onslaught right now. And there's other examples, like occasional examples of good case law that lawyers can use. But generally speaking, though, I think the second thing I want to emphasize is that the popular dimension of constitutionalism is especially important right now. So when we think about these basic principles of Reconstruction, multiracial democracy, free labor, I mean, these are things that huge swaths, the vast majority of Americans, I would expect agree with. But what I would think that they don't necessarily do is connect that to the Constitution and think of those principles as actually constitutional entitlements. And I think that's something that we can do sort of at the grassroots level or outside the litigation context to sort of spread popular consciousness and sort of redevelop maybe a more progressive constitutional consciousness.
Perfect.
Yeah, I agree with all of that. And just echo, I think we live in a challenging time, to say the least, that can be very demoralizing as we see new things emerging each and every day that shock the conscience. But I think the Reconstruction era reminds us of the importance of citizens being engaged in this conversation. The tremendous impact that, as you said, Barrett, non-lawyers, non-politicians had during the Reconstruction moment, participating in debates about the Constitution, even in a not overt way, but discussing the principles and values that undergird the Constitution, principles of freedom and liberty, justice, equality, citizenship. These are ideas and concepts that, abolitionists were discussing, activists were discussing. And I think promoting that today, encouraging that kind of discourse, is going to be important to change the trajectory of our cultural discourse, democratic cultural discourse, which hopefully can push us in a direction, as Sheryll said, where we can change the course of the ship that's slowly heading, or quickly, depending on what you believe, right? In the wrong direction, right? We're like on the Titanic where it's slowly tipping and you're looking over and you're like, it's moving slowly, but like in an hour, I'm gonna be in the water. So this is kind of fast, right? Like I'm quickly dying, even though this ship is moving quite slow. And so you're trying to figure out the time scale of how things are happening. But, you know, the Reconstruction moment helps us to see that this project, this democratic project that we have embraced as a country is an ongoing project. You know, I'm reminded of Langston Hughes. You know, I think about this whole MAGA concept, make America great again, and it always brings me back to Langston Hughes, let America be America again, right? This idea that America is an ongoing project. This myth of American greatness doesn't really exist. What does exist is an ongoing project of making America better, right? Aiming for that greatness, right? Langston Hughes says, America never was America to me. And there's so many people that that's their story. And also, Du Bois had a concept, the as yet America, right? Very similar idea that America is a project, a democratic project where we're trying to realize these foundational ideals. And I think that's the kind of conversation that we need to have now, not returning to some fictional moment of greatness, but taking a really honest assessment of where we are. And unfortunately, you know, President Trump didn't really assess much of anything in the State of the Union in terms of the actual issues that are impacting everyday people and the actual fears that people have in terms of what's happening in our country. But those are the kinds of conversations that we need to have and hope. And, you know, seeing some of that happening at the grassroots level, at the small d democracy level, as Sheryll said, gives some measure of hope that, and of course, seeing it happening in the class amongst our students, I think also brings some level of hope.
Perfect. And so with this, I'm going to kick it to the audience. We have some really wonderful questions that they submitted. And before I read one of these questions, I want to just give a little bit of my perspective in that, like, one of the things I think is so profound about Reconstruction is this was an era after they had worked at abolishing slavery, where like all your intellectual energy was about articulating how this thing was bad and why the bad thing needed to go away. And then once you kind of the power dynamic shift, you can put a lot of energy towards making new things, coming up with new concepts, redefining stuff to promote this agenda of creating an equal, good society. And I think that provides people with a lot of hope because if we don't remember Reconstruction, I think it's really easy for our brain to spend all our time thinking about how to undo bad things. And then there's also that next step, like when you succeed in that, how do I make the good thing? Like, what is that definition of good? What's the language I'm using to precisely define this good thing so I can do it and I can enforce it and I can, if there's a something I miss, I create a structure where I can make a new thing. You know, we have one amendment, we have another amendment, we just keep on going, and this creates an iterative process regarding this concept of creating good and reconstructing the society in that way. And I think Reconstruction provides this like intellectual fuel to encourage people to also think like that, in addition to thinking about how can I articulate these harms and the need to no longer do those. And so I think that's quite inspirational. And to go with the long-term project that this entails, we have a great question from our Netia, and she says, "Do you have any suggestions for a curriculum to teach elementary school age children, grade 3 plus, about Black history, inclusive of Reconstruction?" So, you know, as Sheryll talked about with the court, this could be, you know, a process that we have to think about for decades to get that change. And if we're educating third graders about it, they could be the activists or the lawyers, to, you know, a decade or so down the line that become those voices. And so it's a pretty great question and something to think about. So any of you guys jump in and answer this one, but I think it's a great question.
Well, I had thank God, my kids are 18. Yeah, I have twins, but I went through those stages. And I think for younger kids, the best way to teach Reconstruction would be through characters. Um, there's a lot more than Harriet Tubman and Frederick Douglass. Those are the two characters young people tend to get. Um, so it depends like on the state or whatever, but I do this now with law students. Almost every case, every class, I put up on the screen the faces of who were involved, and I tell the backstory of these people who fascinate me, that had acts of courage. Albion Turgi was I don't know if I'm pronouncing his name correctly. Am I, Luke? Have you heard of Albion Turgi? Am I pronouncing it correctly?
Yeah, I don't know how he pronounced it. I always say Tourget, but I don't
But
know.
such an interesting character who's, I teach about him and his role in the Plessy case, right? So that's what I would suggest. Find a compelling story and a compelling character to impart whatever pedagogical point you're trying to get across to third graders.
And I'll just echo that and provide one concrete example. My wife, she's really into comic books. She has an amazing comic books podcast called Aurora Comics Podcast. And so she's educated me about this new comic that is coming out. They had the first edition that came out on the life of Robert Smalls. It's called Defiant, the story of Robert Smalls. And it's a graphic novel that's being serialized, very accessible to young students. And that's an example, someone who was enslaved, who had a tremendous life story, and is kind of part of that Reconstruction moment. And so that's, I think, a really good example of a resource that's being developed for children. And there are some other projects like that that are out there, but that one is called Defiant, the story of Robert Smalls.
I actually started my career as an elementary school teacher, and now I feel ashamed that I don't have like a good recommendation for curricula. I will say though that there's a recent book by Matthew Nelson called "The Color of Civics: Civic Education for a Multiracial Democracy," and what he shows empirically is that when children are given examples, given stories of American history that center Black agency or agency of people of color, they're actually much more likely to get involved in politics at the grassroots level or participate nationally. So it's like a really fantastic book. And I think, yeah, so just in terms of like thinking about the importance of what you're kind of bringing up. And I guess I would also add like another way to think about teaching Reconstruction is there's a story of Reconstruction. There's also the values of Reconstruction. So, things to help kids practice, practice doing a small multiracial democracy, democratic kinds of experiments in the classroom. That'd be another way to think about teaching Reconstruction.
Yeah, I just wanted to
Go ahead.
I just wanted to add one more example. There's a graphic novel that also just came out in October 2024, similar to Everett Percival's book James, but it's called Big Jim and the White Boy, an American Classic Reimagined. And it's actually very similar to what Everett Percival was trying to do. It reimagines Huck Finn from the perspective of Big Jim, but it's a graphic novel. So it's like it's written in a way that's accessible to youth. And so that's another example of a book that just came out that could help to expose students to thinking about some of these issues.
So one thing I want to add is like I think we're entering a really fascinating era where there's more and more content coming out about Reconstruction that makes it way more accessible than I can really remember in my lifetime. So this is a great opportunity to, if you want to start educating young people about Reconstruction, you have more resources now than you did even a decade ago. But one thing I'd also like to point out is like it's an era with so many unsung heroes. And a lot of those heroes are also white Americans. One thing that I found really fascinating when I started looking at Reconstruction was just the word carpetbagger and how we look at a carpetbagger as something negative. But these were white Northerners who were moving to the South to to a certain extent they were going to rebuild this whole region that was decimated by war. And part of that rebuilding was to help build schools and educate people of color. It's like a domestic Peace Corps. Like there's so many white Americans that made that journey to help create a multiracial democracy. And I really think those stories also need to be told. So we think of Reconstruction as a multiracial democracy and not just something that's, African Americans are the only people that were thriving. One thing I found I think really interesting is like the stigma regarding Ulysses S. Grant has lasted for a very long time, where he was, corrupt or, a bad general. Only recently did they come up with like an autobiography to retell the story of how he's someone that should be celebrated. So there's like the stigma that's painted on people related to Reconstruction. It crosses the racial divide. And as we're teaching people about that, we need to know all of these heroes so that the diverse America that we have today, Reconstruction can inspire so many different people and they can see themselves in it. And so I think we have a really wonderful opportunity now to start doing that. And so with that, I'm going to go to another question from a person named Booker T. Shaw. What can lawyers do to fight for a multiracial democracy today in this climate of great replacement theory that seems to animate the current administration? Just raise your hand and have a go.
Well, I think more than anything, lawyers need to be brave. This is a very scary time, um, especially for folks whose jobs are on the line and have families to provide for, loved ones to care for. And it's scary and also kind of dangerous in some regard to tell the truth. But I think lawyers who are able should be brave and tell the truth and um embrace their duty, their ethical obligation to be public citizens and to call out injustice where they see it. So that's certainly something that every lawyer, I think, can do, but that sometimes is easier said than done in this kind of time we're entering.
I think I would add that apart from whatever you do as a lawyer, you could, if you have any spare time, I always tell my students who are about to graduate that, particularly those who are going to be doing public interest laws, like make it your business to know what organizations uh, in the community you decide to settle in the city you decide to settle in or the suburb, what organization is doing the best building and gathering of multiracial power, right? Whatever you may be doing, it would, even if it's filing lawsuits or something, right? Having a movement that's building multiracial political power so that you can get the deciders to decide better policies is very important. So, being a part of that, knowing, who the best actors are, a lot of times they're faith-based coalitions, joining them if you feel comfortable doing that. But you don't have to be alone in this work. Even knowing the other lawyers who are like-minded, particularly in the federal agencies, if you're like, frankly, part of the resistance now, individuals can't fight these fights alone.
Luke, do you have anything to add?
I mean, I would absolutely echo what Etienne and Sheryll said. And I think, I guess I would add, I don't think we should give up on litigation. I don't think we should give up on any of the political institutions that we have potential access to and influence over. And so, I think one thing lawyers can do, since they have sort of unique insight into how the political system works, is think about pressure points. Think about pressure points at the state and local levels. Think about, in terms of building the networks, Sheryll was kind of saying, including elected officials. Yeah, and then I guess I would also say, lawyers' voices are really important in American society. And I think there's real value. I mean, there are real concerns with truth telling, as Etienne is pointing out, but also real value to others in terms of sort of courage and solidarity to speaking out and speaking to the norms of your profession, and what they are, and reminding each other what they are.
Also, when it comes to litigation, I would say be open to the art of the possible. You can have the arguments based on precedent, but you may want to feel brave and have a section that includes what it ought to be. A different theory, a new theory. Right? Again, I commend anybody who's just wants to kind of think about outside the box. Read Brandon Hasbrook's The Anti-Racist Constitution. It's a good way of just thinking about what could be.
So I agree with all of this, and one thing I would say is the sense of not being alone. That also is like a historical sense. We opened this with Sheryll talking about her ancestors being active participants during Reconstruction to make our society better, and that awareness of those people being lawyers and that education, I'm sure, had a very significant influence in her being a lawyer today and imagining what she can accomplish in the world. And so, like, when Reconstruction is not something that's in your mind, it becomes you can really feel like you're alone in this struggle or there's no precedent for what you're doing. But if you look at it as an era of multiracial democracy where people during a moment of crisis came together to not only just like imagine a better society, but then start doing everything they could to implement it, I think that also gives you inspiration for the struggles that we have today, where you're not alone in the present, but you're also not alone in the past in the historical sense. I think that's very, very significant. And that's partially why we want to emphasize Reconstruction so much today, because this awareness, I think, empowers people in the present. One thing I wanted just to respond to one of the comments, one of the questions that an attendee had regarding carpetbaggers. There's definitely the South definitely had a stigma on Northerners moving to the South during Reconstruction. But the stigma wasn't because Northerners were moving to the South. It was that when they were moving to the South, they were doing things to implement Reconstruction, which was empowering African Americans. And so due to that, they then gave them a stigma as that they were these Northerners coming in and seeking political office and they didn't know what was going on. So the issue is that they were trying to help people of color, not that they were coming to the South. For example, like my father is from Prattville, Alabama. That town was created by a New Englander who moved to Savannah and then realized that the South didn't really have much industry at all. And he thought he could make a lot of money if he moved to Autauga County in Alabama, which was the intersection of, I believe, three rivers, and built a factory producing cotton gins. They love this person. Daniel Pratt is still regarded as Alabama's first and greatest industrialist, and he's a Northerner. So the issue isn't whether Northerners are moving to the South, it's what they're doing when they move to the South that gives the stigma. And carpetbaggers have this negative stigma because they were empowering people of color, and some of them did run for elected office. And so we should look at those carpetbaggers as real champions of multiracial, multicultural democracy and not use the South's narrative as the definition, the defining character of these really courageous white Americans in the 1860s and 70s. And so I think this is supposed to go till 2:30, so I think we might have time for one more question and then we'll give the closing remarks. And so I think this is a fascinating one because you guys all work at law schools and I don't because I'm not a lawyer. But how much do you guys think the panel feel that law schools are resistant to creating more cross-disciplinary courses along the lines that I was talking about of having, non-lawyers kind of weigh in or give their perspectives and have that shape the law? In my experience or his experience, it seems like they're pretty difficult or reluctant to do that. What's your sentiment? Because, that's kind of a Reconstruction idea is bringing in a lot of new voices into the discourse to like make the society better. Anybody?
My institution would be open to that if I was willing to do the work to bring the people in. I mean, we are trying to do more stuff with our School of Public Policy. I mean, if I, came up with a well-constructed interdisciplinary course that would be co-taught by someone from another discipline, and that might include some form of outside citizen participation, I think they might be open to it, but they'd have to be convinced that I could pull it off, and it wouldn't, just devolve into just dialoguing, right? But that's a lot of work that I probably would not take on, to be honest.
I think I'll just note that, legal education more generally has evolved in tremendous ways since the beginning of our country. I mean, historically, there was a time where the lawyer profession was an apprenticeship profession. Other than going to the Inns of Court in Europe, you became an apprentice to a lawyer, and you were given a sort of curriculum that wasn't just the law itself, but it also was philosophical, religious, cultural text, the sort of Jeffersonian method of legal education. And that evolved, and there's a long history of why legal education went into the university, sort of somewhat a response to the Enlightenment era, and the scientific methodification of lawyering is connected to the emergence of the case method in law schools. And so the rise of clinical legal education is sort of a response to early debates in the early 20th century around how you teach the law and how you practice the law. That's, legal formalism and legal realism that predates where eventually getting to critical theory and critical race theory and the like. And so I think there's always been sort of tension within law schools about how you teach the law, what should be included in the curriculum, and how we embrace other kinds of education, other kinds of discourse. I think certainly most recently sort of sparked or maybe ignited by the pandemic, but to be sure it existed prior, is a more concerted effort to engage the topic of racism, the topic of racial justice in the law school curriculum. So there are a variety of law schools around the country that are creating anti-racist centers and movements and curricula that are trying to create those kind of interdisciplinary and cross-disciplinary experiences for students. That's certainly not the norm, but there are a variety of schools that are doing that are experimenting with their curriculum in a number of ways. I think, as Sheryll said, it requires faculty that are also bold enough to embrace that and to take that on. And that's, that sometimes is extra work that doesn't bring extra compensation. And so they need to be committed to that project and passionate about what that project means. Of course, the ABA supporting those kinds of efforts helps to go a long way to make that a reality because of the ABA's relationship with law schools. And so I think it's happening. It's maybe not happening fast enough. The backlash, the banning, the book bannings, the backlash on CRT and all this and that is making it a little more difficult. I think it's slowed down the speed of how things were happening when the pandemic hit, but it's happening. People are talking about it. It's just not the mainstream conversation.
But law schools do a lot of convening, lots of symposiums, lots of lectures, things like that. That's where the public gets to come in and could hear some of this stuff.
Lucien, any last remarks before we close it out?
I guess, just that I see a lot of, I guess as someone who's sort of, been in political science and in law, I see a lot of openness to interdisciplinary work in law. And I think a lot of that turns on the kind of history of the legal profession, the history of legal training, and the recent sort of turn in legal scholarship to be more interdisciplinary for law professors to have backgrounds, PhDs in different sort of disciplinary subfields. And so I do think it'll it'll probably depend a lot, institution to institution, depending on their funding, their bar passage rates, all of that. But there does seem to be a sort of general movement right now where interdisciplinarity is becoming more common. Yeah.
Perfect. And I'll say I agree with the sentiment where there's clearly, like, as Shara pointed out, there's like a practical component. Like, you have to find the person to do it and the bandwidth and all that kind of stuff. As Etienne talked about, there's a clear evolution in how law is being taught, and that's like an ongoing process. And as Luke pointed out, they're they're a bit more interdisciplinary, where like I met Luke at a talk at Harvard Law School where they wanted me to talk about my stuff, and I'm not a lawyer, and I'm here talking to all you guys, and I'm not a lawyer too. And this is clearly an example of the interdisciplinary nature of this and how it's becoming more accessible and the norm. And so I guess with that, we're at 2:31, so it's time to wrap this up. And so I would just like to thank all three of our speakers for being present today. I thought this was wonderful. It was like it was just like three friends chatting, which is a lot of fun. And so yes, so thank you to our distinguished speakers for their thought-provoking insights. We've delved into the constitutional structures that shape our society, the legacies of Reconstruction, and the power of teaching this history in our modern era. As we reflect on today's discussion, I hope it inspires you to question, to learn, and to engage more deeply in the legal and cultural frameworks that govern our lives. Thank you all for joining us. Stay curious, stay critical, and continue the conversation beyond this space. And just want to remind you, we try to have these conversations once a month, so look out for them. We should have another one coming up in April and in May and so on and so forth. And so let's keep the conversation just going in. It's nice chatting with friends and make a new one. So have a great